Thank you to Gloria for the introduction, to Green Mountain Academy for the invitation to speak, and of course to all of you for being here tonight. Gloria mentioned my book, and I couldn't resist bringing it, not because I'm looking for more sales, but because I don't know if you can see the title is Building the Judiciary, and the picture here is fitting given the title. It's a column that stood in front of the Supreme Court, and it's a craftsman shining it. And what you can't see is down at the very bottom, and this is the reason I brought it tonight, it says Vermont Marble Company. The columns for the Supreme Court were made at the Vermont Marble Company in Proctor, and so the photo is actually property of the Vermont Marble Museum up in Proctor. So Vermont connection there. I want to begin with two historical snapshots. Snapshot one. When, after a day's delay, the United States Supreme Court convened for the first time in history at the Royal Exchange Building in New York in February 1790, it was a sorry scene, and even the justices knew it. With only 4 of George Washington's initial 6 nominees even bothering to show up, Robert Harrison, having declined his commission on account of preferring his job as Chancellor of Maryland, whatever that actually is, instead, and John Rutledge, who was confirmed but neglected to show up for a single session of the court for 3 years before resigning to become, wait for it, Chief Justice of the South Carolina Court of Common Pleas. And with the court lacking even a single case to hear, Chief Justice John Jay and his 3 colleagues, you can see the 4 of them there, in attendance, Justices James Wilson, William Cushing, and John Blair. The 4 of them spent the session devising procedures for the conduct of actual business. The justices could not have known then that they would have no such business for another 18 months. But in retrospect, the dearth of activity demonstrated how the court's institutional beginnings were inauspicious and suggested that its likelihood of exerting any measurable direction on the course of American life was slim. Snapshot 2. When, more than 200 years later, the court convened for one of the most dramatic moments of its history at its own building in Washington, D.C. on December 11th, 2000, it was a stunning spectacle, and all of America knew it. With Chief Justice William Rehnquist at the helm, all 9 justices sat at attention for the day's lone case, an election dispute summoned from the Florida Supreme Court, a thorny little matter known as Bush v. Gore. The justices focused their questions that day on the arcane interstices of finely wrought election procedures. But with 2 of the nation's leading lawyers, future Solicitor General Ted Olson and former government litigator David Boies, arguing, and many citizens subsequently listening in via an immediately released and nationally broadcast audio recording, the remarkable and incontrovertible fact that a presidential election hung in the balance raised the possibility that the court sat at the apex of not just the American judiciary, but the entire American political system. Now, the dissimilarity between these 2 snapshots in the court's history could not be more profound. With several distinguished men having refused appointment and the docket languishing without any substantial business, the court of the late 18th century was a feeble institution. It lacked prestige, respect, and power. It had no building, a small budget, and was largely controlled or handicapped by the other branches of government. By contrast, as the current struggle over the nomination of Merrick Garland to replace the late Antonin Scalia suggests, the court of the early 21st century is clearly considered significant enough to warrant a political fight. It is not only prestigious and revered, but also powerful, politically important, and highly contentious. It hears and decides cases in its own marble temple, has a significant budget, and is sufficiently independent from the other branches to govern its own affairs. How did such a dramatic transformation occur? How did the Supreme Court transcend its early limitations and become a powerful institution of American governance? How, in other words, did we move from the court of John Jay to the court of John Roberts, from a court of political irrelevance to one of political centrality? These are effectively the questions that define my academic life, the ones that motivate my teaching, the ones that animate my scholarship, and the ones that, for better or worse, and maybe worse for you if this is going to be boring, structure my talk tonight. They are obviously big questions with a grand historical sweep and a litany of moving parts. And so in trying to grapple with them in a relatively short time tonight, we're going to need to make two sacrifices. First, unlike my courses at Williams, which endeavor a fairly comprehensive survey of constitutional law and politics from the founding to the present, we're going to pick and choose some particular points of interest, glossing over some important pieces of the puzzle to create room to discuss others. Second, unlike my book here, which really seeks to emphasize the ways in which the power of the Supreme Court is about more than just judicial decisions, and the extent to which the court's power resides in a series of contested questions about institutional design and delegation faced by Congress and the president, we're going to focus on the work of the court itself. Even with these limitations, one of chronology, the other of conceptualization, I hope to be able to sketch for you a story that helps you to understand what may be the most radical and thoroughgoing transformation in American political history. Among the things I want to do here are the following. Offer an outline of the court's historical trajectory for roughly its first century and a half, until, say, the Great Depression and the New Deal, focusing on a few critical cases and developments that really serve as essential background in understanding where the contemporary court comes from and how it differs from its ancestors. Pause on 1937 and 1938, effectively the birth of constitutional modernity, to unearth the roots of what will become the heart of the court's project, beginning with the appointment of California Governor Earl Warren as Chief Justice of the United States in 1953. Recap the interventions of the Warren Court in American political life that both establish the court's role as we know it and provoke intense controversy over the legitimacy and propriety of that role. And then fast forward to the present day, really to the last few years, to illustrate some of the court's current work in light of the historical path we've traveled. Even that's a lot, but unlike my students, you won't have a final exam at the end. So let's get started. As a very crude matter, we can divide the history of the Supreme Court into three eras, with each era defined chiefly by the main tension that's manifested in the cases before the justices. From the founding to the Civil War, that tension was the relationship between the nation and the state. From Reconstruction to the New Deal, the relationship between government and business. And from the New Deal to the present, the relationship between government and the individual. Now, I'm not going to spend equal time on each of these three eras, but I do want to touch on each of them, not least since they flow into one another. And understanding that flow is integral to explaining the nature and controversy surrounding the court's power. From its very inception, indeed, even before the fight for independence, proto-American judicial power had been encircled in the battle between political centralization on the one hand and decentralization on the other. The judiciary of colonial America had a substantial effect on the lives of ordinary colonial Americans, but it effectively served as an administrative arm of the crown in North America. And that engendered distrust among the colonies for its close connection to British authorities. In the years immediately following the American Revolution, this uncertainty developed into a sharp tension between those who believed that judicial power was a dangerous threat to democracy and those who believed it was a necessary check on democracy. Seeking to avoid potentially divisive issues while the nation was still in its infancy, political leaders at both the state and the national levels devoted only limited attention to the role of the judiciary, establishing ad hoc tribunals instead of a national judicial system in the post-revolution government created by the Articles of Confederation, and then later spending remarkably little time discussing judicial power at the Philadelphia Convention. The result of those limited conversations, Article 3 of the Constitution, the judicial article, is the shortest and vaguest of the articles establishing the three branches of the federal government. accounting for a mere 369 words, and I have counted, in a document of more than 4,300 words, it does little more than indicate that there is a judicial power of the United States, and that such power is vested in one Supreme Court and such inferior courts as Congress may from time to time ordain and establish. It creates a Supreme Court then, but gives us no indication of how many individuals will compose it. It outlines the types of cases to which the judicial power shall extend, but qualifies even those grants of jurisdiction with such exceptions and under such regulations as Congress shall make. In general, the Constitution declares that a judicial power exists, but offers scant guidance about the precise nature, contour, or extent of that power. That ambiguity, the result of an uneasy and seemingly unbreakable stalemate between supporters and opponents of a strong central government at the convention, led almost immediately to unease in the states. Of the 80 distinct constitutional amendments proposed by state ratifying conventions, fully 16 of them concerned the judiciary. Some of these proposals were motivated by fear that the new judicial system would marginalize and ultimately displace the jury system. But the majority of them manifested concern about the balance of power between federal and state governments. Under the new constitutional system, state and local interests were represented in the legislature through geographic representation and the selection of senators by state legislatures, and in the executive through the Electoral College, but not in the judiciary. With the Supreme Court structured to nationalize disputes by design and having no explicit rules of apportionment or mandated geographic balance, skeptics of judicial power feared that the institution existed to enforce state compliance to the federal government, rather than to represent the states themselves. And when the court issued its first major decision in a case called Chisholm v. Georgia, it seemed they were right, as the court ruled that a state could be sued in federal court by a citizen of another state. Predictably, Georgia went nuts. There's a lot of Georgia going nuts in early American history. No one's from Georgia originally, right? Okay, no offense taken. Georgia went nuts, threatening the death penalty against anyone who tried such a thing. In the end, the fact that Chisholm, this case, was ultimately overturned by the 11th Amendment, Georgia rallied South Carolina and Alabama and a bunch of other states to be against it, did not mean that the court was incapable of being a nationalizing institution. It simply meant that it had not yet grown into one. And for a time, it seemed that it might never realize that promise, that it might always have the potential for power, but lack the willingness or the ability to wield it. After all, John Jay, that first Chief Justice of the United States, was sufficiently bored with his job that he became envoy to England while sitting as Chief Justice. And then, upon being elected governor of New York, resigned as Chief Justice altogether. That's an unthinkable move today, but it seemed a perfectly rational one in the early republic. At least until John Adams, in perhaps the most significant decision of his presidency, turned to a 45-year-old Virginian, a one-time captain in the Continental Army, and a former member of the Virginia Assembly and briefly the U.S. House of Representatives, a lawyer, a diplomat, and a Federalist partisan, to take the helm of the court. That Virginian's name was John Marshall. And for the century and a half that followed, his court would be the benchmark for all future ones. Why? Because as America's first great jurist and its last great federalist, Marshall accomplished the twin tasks of forging a national government and sustaining a national economy, all while in judicial garb. Combining a political vision of asserting federal power generally and federal judicial power specifically, with an economic vision that took a broad view of interstate commerce and insisted on strict adherence to contracts, Marshall took an institution that was scared to purr and made it roar. The key move here, kind of liked that analogy, actually. The key move here was a case you may have heard of, a case called Marbury versus Madison. It's the case that your grandchildren are learning about in 11th grade history, for example. It occurs against the backdrop of the 1800 presidential election, as hotly contested and chaotic of an election as America has ever experienced. And yes, I include this election in that. The Federalists, following the passage of the widely despised Alien and Sedition Acts 2 years prior, are roundly repudiated by the Democrat-Republicans. And following an electoral college tie with Aaron Burr, Thomas Jefferson is elected to succeed John Adams as president. If any of you have seen Hamilton, or as my son and I have listened to the cast album, Burr is obviously a major figure, and there's actually a song in Hamilton, The Election of 1800 in Act 2. But at this point in American history, let's remember that the inauguration of the new president and Congress isn't until March. Today it's in January, then it was in March, which means that's almost 4 months of a lame duck government still controlled by these outgoing Federalists. So, kicked out of office by the voters and seemingly headed for a political abyss, what did the Federalists do? They took advantage of their rapidly ending majority and pursued a substantive policy agenda, including creating all sorts of governmental positions to be filled before the presidency changed hands. One of those partisans was a man named William Marbury, who was promised a relatively inconsequential position, to anyone but him at least, as a justice of the peace in the District of Columbia. Now, the way you are notified of your position is with a commission, a formal document that comes from the Secretary of State. And in order to be valid, in order to be executed, the commission must be, as the great Stevie Wonder knows, signed, sealed, delivered. All right? That's what makes the commission valid. And in class, I usually play a little clip of Stevie Wonder, but I didn't know what our audio capabilities would be, so we skipped that today. It sounds simple enough in theory, but in practice, in the frenzied last days of the Adams administration, Marbury's commission encounters some problems. By this point, Oliver Ellsworth had resigned as the second Chief Justice, and Adams had named his Secretary of State to replace him. Who was that Secretary of State? None other than John Marshall. Well, by the last days of the Adams administration, Marshall was, at Adams' request, serving both roles, Secretary of State and Chief Justice of the United States. And evidently, the double duty overwhelmed him, because he goofed on Marbury's commission. When Marshall left the White House, officially relinquishing his Secretary of State hat and donning his Supreme Court robe full time, the commission was, much to the chagrin of both Stevie Wonder and William Marbury, signed, sealed, but not yet delivered. So when Jefferson moves in, and legend has it that the Jeffersonians were waiting with stopwatches to take control of the White House, Marbury's commission was waiting for the new Secretary of State. At Jefferson's urging, that Secretary of State, father of the Constitution and future President James Madison, refuses to deliver Marbury's commission. So Marbury brings suit against Madison directly in the Supreme Court, asking the court to issue what's called a writ of mandamus, a legal order compelling Madison to give Marbury his job. A monumental piece of legislation known as the Judiciary Act of 1789, one of the very first pieces of legislation the first Congress passes, says that the court can do this, and Marbury wants the justices to do it here. Now, the case presents a real quandary for John Marshall and his brethren. On the one hand, Marshall can order Jefferson and Madison to give Marbury his commission. But if he does that and the president refuses, the court looks impotent and irrelevant. On the other hand, if he doesn't order them to give Marbury his commission, then it looks like the court is scared of the other branches and not an independent institution in American government. Either way, the judiciary looks weak compared to the executive. So what does Marshall do? Like any good lawyer, he asks a series of questions. Are there any lawyers in the room? No, couple. All right, series of questions. First, does Marbury have a right to the commission? Yes, Marshall says. The job is rightfully his, and Jefferson is wrong for denying it to him. Second, Does Marberry, have a remedy for this wrong? Marshall says, yes, again, courts can offer a remedy when a right has been infringed. Third, is the Supreme Court the right institution to issue that remedy? And here's the rub. No, Marshall says, it is not. Why? Because the provision of the act authorizing the remedy that Marberry seeks is itself inconsistent with the Constitution. And if law, which is ordinary, conflicts with the Constitution, which is fundamental, well, then the Constitution, by virtue of its supremacy, trumps. No pun intended with our current presidential candidate. And it is the court's job, whether it wants to or not, to say what the law is. From a seemingly unwinnable position, Marshall manages to win. With neither force nor will, but merely judgment, as Publius says in Federalist 78, he snatches victory from the jaws of defeat. Marshall says he is right and Jefferson's wrong. But since he doesn't order the president to give Marberry his commission, there's no judicial order for Jefferson to deny. I mean, he's certainly not going to order Madison to give a Federalist a job. So he's left only to fume and famously accuse Marshall of twistification of the Constitution, before buying, without any constitutional authority to do so whatsoever, the Louisiana Territory 4 days later. Part of Jefferson's anger was being outwitted by his rival and distant cousin. But part is also about Marshall's insistence that the Supreme Court has not only a place at the table of American governance, but also an effective veto over things the political branches might choose to do. This is what we know today as the power of judicial review, the ability of the judiciary to declare legislative acts null and void. Although Marshall was not the first person to suggest this power, and although his invocation of it did little to silence his critics, Marberry asserted that the court could strike down an act of Congress if, in the judgment of the justices, it conflicted with the Constitution. And once Marshall had taken that step, it was all too easy to claim, as he would do in a later case called Fletcher v. Peck, which again involves Georgia, that the court could also strike down an act of a state legislature if, in the judgment of the justices, it conflicted with the Constitution. The combination of these two cases, Marberry and Fletcher, meant that the court had carved out a meaningful role for itself, and that part of that role would be enforcing national standards against state actors. Even after Marshall passed in 1835 the Liberty Bell in Philadelphia, reportedly developing its epic crack tolling Marshall's death, the court continued to wrestle with how to balance federal power and states' rights, national needs and local prerogatives. That Marshall was an unabashed nationalist, allowing Congress broad regulatory power over commerce and aggressively invalidating state laws impeding upon contracts, did not mean that all of his successors would be nationalists as well. But to the extent that the Constitution itself created a compound republic, without agreement about whether that republic was a consolidation of states or a compact of states, and to the extent that Marshall had inserted the judiciary into the fight between these two constitutional visions, the compromise over federalism became a near constant source of judicial attention until it was shattered by secession. When the battles of the Civil War had ended and the nation was forged anew during Reconstruction, the court famously remarking that the United States was an indissoluble union composed of indestructible states, the judicial gaze followed the political gaze elsewhere, namely to business and industry. In the Gilded Age of rapid industrialization and corporate consolidation of capital, not all constituencies found themselves prosperous, and those that did not pressured policymakers for reform. Yet the court, stocked in no small part with former corporate lawyers, almost invariably sided with laissez-faire critics of what the famous social Darwinist William Graham Sumner once called the absurd attempt to make the world over. by which he meant regulation. The result of the court's fairly consistent pro-business jurisprudence over this period, striking down legislation about things like the income tax, child labor, and minimum wage, was a series of clashes with social movements seeking to protect citizens against the ills of unbridled capitalism. I like to think of these clashes as ocean waves, waves that travel a long way before they're really visible, following one after the other, building slightly in intensity on the one preceding it, before crashing harder and more violently on the shore. In the 1880s and 1890s, there was populism. In the 1900s, 1910s, and 1920s, there was progressivism. In the 1930s, there was the New Deal. With each conflict, the court grew more audacious in striking down legislation, enraging and alienating itself from a wider sector of society each time. And with each conflict, the resulting attacks on the court grew more serious and caustic. From calls for clearer legal standards, to desires for judicial recall and popular votes on judicial decisions, to plans for court packing. The iconic and in some ways emblematic clash of this period was a case called Lochner versus New York. Lochner concerned a New York statute limiting the number of hours bakers, including Joseph Lochner, who owned a mom-and-pop bakery in Utica, New York. It limited the number of hours bakers could work in a given week. It was, in some sense, a pretty ordinary type of law that was familiar in American jurisprudence and usually affirmed as a matter of course. But the court, increasingly strident in its capitalist sensibilities and building off a series of legal rulings expanding the reach of the idea of liberty beyond mere freedom from bodily restraint, struck down this law as a violation of what it called liberty of contract, which it rooted in the 14th Amendment. What was remarkable about Lochner was the way it asserted an expanded judicial prerogative to assess both the constitutional propriety of a law and the policy wisdom behind it. Not only does the Constitution allow it, but is it a good idea? Understanding the constitutional mandate of due process to include not only the procedures by which the law was passed, did it go through the proper channels, but also, paradoxically, the substance it sought to regulate. Naturally, this sort of posture provoked substantial disagreement about the contours of the judicial role and the scope of judicial power. Should judges defer to legislators or supervise them? Should they focus on the manner of legislation only or its objects as well? Should they approach this awesome power of judicial review with a presumption or skepticism of a law's constitutionality? The court's willingness, in Lochner and its progeny, to answer these questions in a way that magnified, in a way that aggrandized its own powers, even at the expense of the majority of the American citizenry, suggested that the court, which had been famously cautious in Reconstruction before beginning to reassert itself again in the Gilded Age, it suggested that the court had recovered from the self-inflicted wounds resulting from its infamous pro-slavery decision in Dred Scott. Indeed, for a court that had supposedly been humbled in the 1850s, when there were members of Congress saying that we should abolish the Supreme Court and create a new one in its place, a court that had supposedly lost all the prestige and power built by John Marshall, it was extremely comfortable wielding judicial power in pursuit of what it regarded as the traditional Constitution. In fact, it was not until the economic crisis brought about by the Great Depression led the public not once but twice to validate the interventionist vision of Franklin Roosevelt's New Deal that enough justices got cold feet about their continued intransigence in the face of political innovation. Throughout FDR's entire first term, indeed until March of 1937, just into the beginning of his second term, the court remained committed to a constitution that was fixed for all circumstances, that protected local prerogatives and individual liberty against governmental intervention, and that supervised lawmaking with quasi-legislative judgments. And then, with the economic survival of the people, the political structure of the republic, and the constitutional character of the nation at stake, the court blinked in 1937. The court that had fastidiously opposed centralization of governmental power over the economy, and that had viewed itself as a vital check on the judgment of Congress and the executive, was gone, replaced by a court that would effectively abdicate what had been its role in arbitrating disputes between government and business, and by extension, sanctioning the growth of the administrative state. The most interesting, if also one of the most obscure statements of this shift, and a hint of what was to come in the latter half of the 20th century, came in a 1938 case called United States versus Caroline Products. At issue here was the constitutionality of the Filled Milk Act of 1923. This was actually the statute, which prohibited the shipment in interstate commerce of milk mixed with vegetable oil, a product called millnut. Has anyone ever seen or heard of this? Okay, neither had I. I actually found this picture this morning. But you can see down there at the bottom, the Caroline Products Company. Right? So it was this product that Caroline Products came up with, which was a kind of synthetic milk. It was milk and some skimmed milk, some whole milk, some skimmed milk, and millnut, vegetable oil, effectively. We're supposed to mix them together. And there were some claims that this was injurious to the public health. Why would you want your children drinking millnut when they could be drinking milk? In reality, Congress probably regulates it because the dairy industry wants them to, and this hurts the dairy industry. Regardless, in a very brief opinion in the United States versus Caroline Products, the court sustains the legislation, sustains the Filled Milk Act of 1923, noting that it was no longer in the business of second-guessing the legislative judgment or policy wisdom of Congress on matters of economic regulation. And that since this statute, since the Filled Milk Act, was not unconstitutional on its face, the court was disinclined to scrutinize it further. That kind of ruling itself was mundane and unremarkable following the 1937 switch in time that saved 9, which is the name that's given to the court's about face. But in a footnote, the court, and by the court, I mean Justice Harlan Fiske Stone, and by Justice Harlan Fiske Stone, I mean his law clerk, Louis Lusky, laid out a proposition that would come to dictate its workload and define its approach ever since. In a nutshell, Footnote 4, the most consequential footnote in American constitutional history, suggested that even as economic regulation was presumed constitutional, things like the Filled Milk Act, even as we presume that that is constitutional, different types of legislation might deserve different levels of scrutiny and might be held to different jurisprudential standards. So economic regulation, presumed constitutional. Other things, maybe not. More than that, the court even suggests in 3 brief paragraphs the kinds of legislative subjects that might, and the opinion is full of haunting language like might and we need not inquire now and nor is it necessary to consider, these sorts of things. The 3 kinds of legislative subjects that might trigger a closer, more rigorous look. The first one is legislation involving subjects mentioned in the Bill of Rights. The second is legislation involving the democratic process. And the third is legislation targeting discrete and insular minorities. Although Lusky, the author of the footnote, himself later said that it was merely intended as a trial balloon to provoke discussion and debate in the academy, it did quite a bit more than that, floating in the jurisprudential air until the right moment and the right man came along to champion it. That moment was 1953. And that man was California Governor Earl Warren. As the story goes, Warren, who had appeared as a candidate of both the Republican and Democratic parties for California governor, and I don't mean he was a Republican one election and then he switched to being a Democrat. There was, I believe, 2 elections in which he was both the Republican and Democratic nominee for governor. Warren was a potential Republican presidential candidate in 1952 until Dwight D. Eisenhower, seeking to secure Warren's delegates and improve his chance at securing the nomination for himself, offered to appoint Warren to the first seat on the Supreme Court in exchange for his support. When Chief Justice Fred Vinson, an old card-playing buddy of Harry Truman, that's how he ended up on the court, it was kind of blatant cronyism, when Chief Justice Fred Vinson suddenly dies, a death that famously prompted Justice Felix Frankfurter to quip that it was the first solid piece of evidence I have ever had that there is a God, Eisenhower tried backing out of the pledge on the grounds that he had not promised Warren the chief justiceship. But Warren insisted that no such proviso had been broached, and Eisenhower kept his word, fully expecting Warren to operate in Ike's own mold of moderate republicanism. Well, when it soon became clear that Warren's jurisprudence was anything but moderate, and in fact that he barely resembled a Republican on the bench at all, Eisenhower was outraged, supposedly remarking that appointing Warren was, quote, the biggest damn fool mistake I ever made, end quote. He also later answered a question from a reporter about whether he had made any mistakes during his presidency by holding up two fingers and saying, and they are both sitting on the Supreme Court. One was Warren, the other was William Brennan, who will join the court in 1956, but serve as Warren's right-hand man until Warren leaves the court in 1969, and then carry Warren's legacy on all the way into the 1990s, long after Warren himself had passed away. With Warren in the court center chair, the court's focus shifted again. For its first 70 years or so, if we remember, the court had sought to balance the demands of the nation and the rights of the states. Then the Civil War and Reconstruction repudiated compact theory and reconstituted the Union. For its next 60 years or so, the court had tried to balance the capacity of government to regulate and the desire of business to grow. Then the Great Depression brought the New Deal, and an economic interventionist state was here to stay. Beginning roughly in 1937, 1938, but really taking hold when Warren replaces Vinson in 1953, the court would seek to balance the authority of government to enforce societal will against the freedom of the individual to do or be as he wished. In doing so, the court carved out a new and controversial role for itself as the guardian of individual rights. And it articulated a set of new and controversial jurisprudential principles for the nation to follow. And it did so, in no small part, according to the values suggested in the 3 paragraphs of Footnote 4: freedom, democracy, and equality, each of which essentially serves as a distinct body of iconic Warren Court jurisprudence. Let's consider them in reverse order, starting with Footnote 4's paragraph 3 and moving upward to paragraph 1. Not least since that's more or less the order in which the court develops them. And I'll do so with references to 3 different sets of cases here. First, on issues involving discrete and insular minorities, the Warren Court established itself early and emphatically as the protector of African Americans. In Brown v. Board of Education, it declared that in the field of public education, separate is inherently unequal, overturning the half-century-old Plessy v. Ferguson and ending, at least officially, the practice of segregated schools. In Cooper v. Aaron, it stated, with all 9 justices claiming joint authorship of the opinion for the only time in American history, the only time at that point, it remains the only time since, the court stated that its interpretation of the Constitution in Brown was supreme and binding on all federal and state officers. In Heart of Atlanta Motel versus United States and Katzenbach versus McClung, it upheld the landmark Civil Rights Act of 1964, the first comprehensive piece of civil rights legislation since the court had killed the Civil Rights Act of 1875 more than 80 years before. It upheld it as a valid exercise of congressional authority over interstate commerce. I have John Marshall to thank for that one as well. Standing up for those who who the political system did not let stand up for themselves, the Warren Court pursued and pushed a racial liberalism beyond what state or most federal institutions were willing or able to initiate. Second, on issues involving the democratic process, the Warren Court established itself clearly and consistently as the caretaker of representation and voting. In Baker versus Carr, it announced that questions of representation, of how legislative district lines were drawn and how voters were grouped within those lines, was a question perfectly appropriate for judicial resolution. In Reynolds v. Sims, it pioneered the idea of one person, one vote, and demanded that legislative districts, which the court said needed to be oriented around voters rather than trees or acres, be of roughly equal proportional size, population size, In South Carolina versus Katzenbach and Katzenbach versus Morgan, it upheld as constitutional and broadened the scope of the Voting Rights Act of 1965. For a half century after, the chief tool in brushing away discrimination and disenfranchisement of subtle and not so subtle varieties alike. Recognizing that democracy required equal access to the poll and fair representation in the legislature, the Warren Court counterintuitively used its undemocratic authority to buttress the pillars of democratic politics. Third, on issues involving the Bill of Rights, the Warren Court established itself rigorously and reliably as the keeper of the people's liberties. In Engel versus Vitale, on Long Island, it insisted that school prayer infringed on the separation of church and state required by the Establishment Clause of the First Amendment. In Griswold versus Connecticut, it outlined an unenumerated, meaning unlisted, right to privacy, a combination of what the court called penumbras formed by emanations, and those are actual real concepts, not made up like they sound, from the First, Third, Fourth, Fifth, and Ninth Amendments, a right of privacy that was broad enough to incorporate decisions about intimate conduct, including contraception and eventually, of course, abortion. In Miranda versus Arizona and Gideon versus Wainwright, it provided essential protections for the accused and criminal defendants as a way to infuse greater fairness and equity into the justice system. Expanding the Bill of Rights to protect formerly unprotected or at least unstated rights, the Warren Court swept into its orbit and into the national consciousness more generally, a set of issues that went to the core of daily life in America, even if the particular Americans who raised them were somewhere between disregarded and despised by most of the American public. In the end, then, by facilitating the court's transition away from economic regulation and toward individual rights, the political clash and the judicial capitulation that occurred in the New Deal actually laid the groundwork for a judiciary with a more potent and more pliable authority over a wider array of American political subjects. It not only enabled government by judiciary, a government, that is to say, where judges engage in legislative and administrative functions of prescribing policy, but also allowed, perhaps even required, greater interpretive flexibility to discard old precedent and to discover new ways of reading old provisions. In other words, the Warren Court, and it is difficult to overstate this point, revolutionized both the judicial role and the judicial craft. For some, that revolution was a cause for celebration, with Warren himself lionized as a man who had made America a better place. For others, including politicians like Barry Goldwater and Richard Nixon, lawyers like former Attorney General Edwin Meese and future Chief Justice William Rehnquist, and intellectuals who began organizations like the Federalist Society, Warren's revolution had been wholly illegitimate, led by a renegade justice hell-bent on destroying democracy and contributing to a veritable breakdown in the American social fabric. Depending on where you were in the 1960s, some of you may have seen "Impeach Earl Warren" billboards on the highways. But But regardless of whether it was a golden age to be celebrated or a cautionary tale to be told, the Warren Court has, for better or worse, replaced the Marshall Court as the one court against which all others are measured. So where, you might ask, does the contemporary court, does the Roberts Court measure? There's some difference of opinion on some aspects of that question. Does the Roberts Court practice more judicial minimalism, deciding only what is necessary and applying its rulings as specifically and narrowly as possible than its predecessors? Or has the Roberts Court operated as a less partisan body with fewer 5-4 splits of justices neatly aligned according to the president who appointed them, and more opinions manifesting unanimity or at least cross-cutting voting patterns? Or is the Roberts Court transitioning from a staunch conservative court to a more moderate or even, on some issues, fairly liberal court? I can slice and dice each of those questions both ways, depending upon which cases are under consideration. In part because it's still ongoing, with 3 changes of membership already in the books and 1 more soon to come. In part because Roberts himself has a very different persona and a very different understanding of the Chief Justiceship than either his former boss and immediate predecessor, William Rehnquist, for whom Roberts clerked, or the man whom Rehnquist developed his judicial philosophy in opposition to, Earl Warren. The Roberts Court is a difficult one to pin down definitively. But what I can tell you, what I think is certain beyond all reasonable doubt, is that we still have a court that views itself as the center of American government, and that has no qualms about introducing itself into live, contested political debates. At least that's the perspective we see recur again and again, albeit in slightly different forms over the past decade. Take the issue of gay marriage. In 2013, the court decided in Windsor versus United States that the Defense of Marriage Act's definition of marriage as a union of one man and one woman was an unconstitutional violation of, well, Justice Kennedy wasn't quite sure, but mostly the Fifth Amendment's Due Process Clause. At the same time, it offered no judgment, it said, on state gay marriage bans, even speaking favorably of federalism as a way to ensure that different states can embody different values. But then, only 2 years later, in Obergefell versus Hodges, the court struck down gay marriage bans nationwide, substituting, rightly or wrongly, its judgment for those of state legislators and their constituents. In doing so, it applied a uniform standard to state marriage laws and put a halt to debates and discussions about marriage equality that were already underway coast to coast. Or take healthcare. Despite a case that most legal experts thought was flimsy, the court heard a constitutional challenge to the Affordable Care Act, aka Obamacare, in National Federation of Independent Business versus Sibelius in 2012. And in fact, in a rare instance of the post-New Deal court suggesting that Congress had exceeded its Commerce Clause power, the court actually found the statute unconstitutional under the Commerce Clause before finding a way to sustain it under the Taxing and Spending Clause. Even after that, the court would entertain a statutory challenge to the legitimacy of the federal subsidies provided by the act, raising the prospect that the court would functionally eviscerate a statute that it had previously deemed constitutional. In the end, the court turned away that challenge too in King v. Burwell, but not before making the Obama administration sweat and throwing into real peril the stability of both the healthcare industry and the insurance market. Or take race, whether in the form of affirmative action or voting rights. In the former, the court has been engaged in a now 4-year back and forth over the status of a University of Texas affirmative action plan. At every step, lower courts approved the Texas plan, deferring to university authorities about the narrow tailoring of their racial preferences and the need for such preferences to provide the best academic experience to its students possible. And at every step, the court would send the case back to the lower courts because it did not think the Texas plan had been scrutinized enough or did not think it had been scrutinized properly, or did not think the correct legal standard had been applied. At the end of the most recent term, in June, the court finally found the Texas plan to its liking and disposed of Fisher versus University of Texas after multiple remands, that means sending the case back to lower courts, that probably made all the parties in the case feel like they were chasing their tails, and certainly introduced widespread confusion about the legitimacy of racial preferences in higher education and beyond. In the latter, in voting rights, the court dramatically struck down the Voting Rights Act of 1965, perhaps the most successful piece of federal legislation since the GI Bill, because in some sense, the court thought it had worked well enough to no longer be necessary. Despite the fact that Congress had, following extensive research and testimony into the effects of the Voting Rights Act, despite the fact that Congress had overwhelmingly reauthorized the statute on a number of occasions, the court deemed it outdated and told Congress it would need to update its provisions in order to pass constitutional muster, without pausing for a moment to consider what democracy in certain parts of the country might look like without the sword of the Voting Rights Act to enforce its legitimacy. Campaign finance, recess appointments, the death penalty, I could go on, but I hope the point is sufficiently clear. In case not, it is this. Despite Chief Justice Roberts' rhetoric about doing nothing more than, quote, calling balls and strikes, as he likes to say, he leads a court that remains willing, maybe eager, or perhaps even desperate to assert not only the desirability, but also the necessity of regarding the judiciary as the supreme arbiter of constitutional meaning and the most important voice in constitutional government. It's a sentiment that, when you really let it set in, is hard to contemplate being conjured, let alone uttered, at the start of the great American experiment in constitutional democracy. America, it goes without saying, is hardly the same nation today it was 2 centuries ago. And American government, what with the rise of the federal regulatory state, the growth of presidential power, the institutionalization of political parties, the inclusion of women and African Americans, and any number of other fundamental developments, hardly has the same contours and character it had when the Constitution was framed. With all due respect, though, to those grand political changes, none, in my opinion, rivals the transformation of the Supreme Court as an institution of American politics. Why? Because far from the uncertainty and frailty that defined its origin, the court unmistakably stands today as an institution of independence, authority, and power, an institution the nation's founders would have scarcely recognized, and one they could have hardly imagined. Thanks for listening. I look forward to your questions. Okay, so I think there's a couple ways to take it. So you're right that Roe v. Wade, establishing the right of an abortion, occurs in 1973, which is during the Burger Court. The Burger Court and the Rehnquist Court, which are the two that succeed the Warren Court, are supposed to be conservative. And in fact, the Burger Court is often referred to as the conservative counter-revolution that wasn't, and is thought about as a failure. There's a way in which that's true of both Rehnquist and Burger before him, and there's a way in which it's not. The way in which it's true, I think, is that there was not a complete rollback of what the Warren Court wanted, right? Or what the Warren Court had done. If we imagined it, as a trend line, and the Warren Court was sort of moving along this way, we didn't go back to where we were before the Warren Court, when either the Burger or the Rehnquist Court was over. There was some continuation, some seepage. A case like Roe v. Wade manifests a very Warren Court sensibility, even though it's in 1973. And the other way in which it does not become conservative is that neither the Burger nor Rehnquist Court, despite the fact that conservatives were complaining about how the Warren Court was using judicial power, neither of them really decided they were not going to use judicial power very much, right? Conservative critics of the Warren Court said, judges shouldn't do these things. This should be democracy. The Warren Court kind of heeds that in some areas. The Rehnquist Court doesn't at all. The Rehnquist Court fully sees that judicial power is a tool to be used, and it simply uses it for other ends. So now, the way in which it is conservative is those ends. So the Rehnquist Court era which goes from the late 1980s until 2005 when Rehnquist passes away and John Roberts replaces him, is known for its commitment to federalism, to turning back the clock a little bit on the growth of national and federal power. We talked about 1937 and 1938. When the court switches in 1937, it does not strike down another act of Congress as exceeding Congress's Commerce Clause power until 1994. And that's when the Rehnquist court does it in a case called United States v. Lopez, which involves the Gun-Free School Zones Act. And the court had been timid in that realm, had removed itself from that realm entirely. And what Rehnquist and his colleagues, Scalia and Thomas and O'Connor and Kennedy, do is it gives the court teeth again in that realm. Now, does it undo, if you were a critic of everything that had happened since the New Deal, if you were a critic of the New Deal, does it undo the damage? Not even close, right? But it does begin to push back in the other direction. There are other areas in which we could think about the Berger and the Rehnquist courts slowing the pace of change. And if we think of conservatism not just as the sort of political right in America, but in the sort of more Burkean sense of slow, measured change, respect for tradition, things of that nature, then those courts were more conservative in that regard. But they certainly did not undo what the Warren Court had done, as many of their advocates and proponents had hoped. Yeah. So the question is about the ramifications or the significance of the Senate refusing to hold hearings, let alone confirm Merrick Garland to replace Scalia. So there's the legal element, the sort of judicial element of it, and then there's the politics of it, obviously. On the legal element, the judicial element, what happens is now you have a 4-4 court, okay? And there have been times in American history where we had an even number court. There's actually, as I mentioned earlier, the Constitution doesn't say anything about how many members there are in the Supreme Court. And so the membership of the court bounces around from 5 to 6 to 5 to 7 to 9 to 10, back to 9, where it's been since the late 19th century. And there have been moments when there have been even justices, and that's been regarded as problematic for a couple reasons. Chief among them is it presents the possibility of a tie. Okay? Now 5-4 technically has that possibility if a justice recuses him or herself, which Justice Kagan has done since she was Solicitor General for Obama. So there's been times that she's recused herself since she's worked on a case as Solicitor General. But generally 9-member courts don't tie. 8-member courts, as we've seen a couple times at the end of term, do tie. And what a tie means is it means that the lower court ruling stands. But it doesn't stand as national law. It stands as good law where it was issued. So the country is divided into a number of judicial circuits. Here in Vermont, you're in the Second Circuit, oddly enough, since both New Hampshire and Massachusetts are in the First Circuit, but Vermont's grouped with New York and Connecticut. So the Second Circuit, so any case that's heard by the Second Circuit Court of Appeals, which is based in New York, that goes up to the Supreme Court and it results in a tie ruling, the judgment of the Second Circuit stands, but only in the Second Circuit. So now imagine an instance in which the Second Circuit, which tends to be a fairly liberal circuit, has a ruling on some issue, and the Fifth Circuit, which is Texas and Louisiana and is a very conservative circuit, has the same issue, as often happens, and has a different ruling. You would actually have, not on questions of state law, but on questions of federal law meaning one thing in Texas and another thing in Vermont. So a 4-4 court raises the possibility of that or increases the likelihood of that. There are also claims, and these I put somewhat less stock in, that the court simply can't function at 8 members because the workload's too high. These people have a good job, let me tell you, okay? The court has virtual absolute control over its docket. This wasn't always the case. The court used to be burdened with all sorts of cases it didn't want to hear, cases that people had automatic rights to appeal to the Supreme Court that the court had to hear. That's been gone functionally since 1925, but the court picks and chooses the cases it wants to hear, and the court's workload has continually diminished to something like 70 or 75 cases a year now it hears. So these people lead a good life. They take plenty of vacations. They work very hard, admittedly, but there's no reason that the court can't function with 8 members. Now, the more broader sort of political element of it, and I hope you'll come whenever it is next week when Matt Dickinson's here, because he'll have stuff to say about the politics of it as well, but I'll give you my take, and maybe he'll agree or disagree. The politics of it are pretty interesting. In large part because we've really never seen anything like this, right? I mean, the level of Republican obstructionism and sort of stalemate that is going on around the Garland appointment is just unprecedented. Right? So there have been times that judges have been appointed or judges have been nominated and the Senate has dragged its feet, or the Senate has opposed and voted people down. That's happened certainly plenty of times. But to refuse in most instances to meet with the president's nominee, and then even those people who meet with them, many meet with him, they say, just to tell him that they're not going to vote to hold hearings, let alone vote to confirm him. It is really unprecedented, and what it's done is it's continued to raise the temperature of political brinksmanship, right? We've seen this in the debt ceiling debacles, the fiscal cliff, all of this stuff, the sort of hostage-taking approach that we've got now in American legislative politics. And that is corrosive, and it leads to problematic relationships between the parties, right? So there's a whole series there was a couple of years ago that Obama wanted to nominate a woman named Caitlin Halligan, who had been a lawyer in New York, was on the Second Circuit for a time, wanted to nominate her to the Second Circuit. She'd been a lawyer in the New York State government, and the Republicans refused because she had once represented clients who sued the gun industry. Okay? So they refused to do that. Now, did they refuse it because they didn't like her gun politics? In part, but they also refused it because the Democrats had refused to confirm George Bush's nomination of Miguel Estrada. Why did the Democrats refuse to confirm Bush's nomination of Miguel Estrada? Because the Republicans had previously refused to confirm Bill Clinton's nomination of Elena Kagan. Why did the Republicans refuse to confirm Clinton's nomination of Elena Kagan? Because the Democrats had previously refused, before ultimately relenting in confirming Bush's appointment of John Roberts, right? I mean, so you can see how this becomes cyclical, and my point isn't to say that it's a plague on both of our houses, right? I mean, it's not that both parties are equally at fault. I mean, what the Republicans are doing in the current climate is unprecedented, and so they're responsible and at fault for that, in my view. But it does suggest that it poisons the well and makes it very hard to do business with one another going forward. It also increases the likelihood that the filibuster is simply going to be nuked, right? So if we see a Clinton victory in November, as I fully expect we will, and the Democrats happen to take control of the Senate, which, depending what happens next door in New Hampshire with Kelly Ayotte, and in Ohio with Rob Portman, and in Florida with Marco Rubio, and some other places is a possibility in the case of a landslide. If the Democrats take control of the Senate and the Republicans try to filibuster a Clinton Supreme Court nominee, they're just going to nuke the filibuster, and that's going to be the end of it. But some people will celebrate that and think that's great. The filibuster is an anti-democratic institution. Others will say, no, the filibuster is crucial in slowing the pace of change and blah, blah, blah. But regardless, it has contributed to both a sort of continued corrosion of political goodwill and has raised the stakes for fairly radical institutional transformation. You want to follow up? Yeah, go ahead, and then we're going to. Okay, great question. How does Brown versus Board of Ed end up as a unanimous decision? Originally, it wasn't, right? So Brown versus Board of Ed is originally heard earlier, right, when Fred Vinson is still Chief Justice. And it actually is going to come down in favor of segregation on a very closely divided vote. But there was uncertainty, and one of the justices had not made the oral argument. And so Vinson decides, we're going to re-argue it next term. In the meantime, Vinson dies. Warren comes. This is, again, Frankfurter's quote about evidence of God. And Warren, in part by force of personality, rounds up justices to this cause. Right? Warren was sort of fond of saying, and was prone to saying, but is it fair? That would be the line that Warren would ask his clerks when they were debating matters of law. And so Warren, who was a very successful politician, remember, in California, went around to each of his colleagues and effectively browbeat them to vote unanimously in Brown. Not only did Warren want the decision to go the other way, thought that it had to vote to strike down segregation, to integrate schools, but he wanted it to be unanimous because he knew, correctly, that a 5-4 or even a 6-3 or a 7-2 decision would make it look partisan, would make it look ideological, and would give ammunition to the forces for segregation in the South. That, well, if we just get some new justices, this will change. Oh, this is just a liberal Northern or Californian elitist interpretation of the Constitution. And Warren wanted to avoid, whether that was true or not, Warren wanted to avoid that impression. He wanted to show that, no, this was a living truth. The Supreme Court building says equal justice under law on it. And Warren wanted to prove that even young African-American school children received equal justice in the form of integrated schools. So it's really Warren goes around and convinces through moral suasion, really reasoning with people to say this is the morally correct thing to do, and it's institutionally imperative that we do it together, that we do it unanimously. He even goes, I forget the particular justice, there's someone in the hospital at the time, and Warren even goes to him in his hospital bed and effectively says, like, I need you to change your vote and vote for this. It's why the case I mentioned 4 years later, Cooper v. Aaron, which involves Central High School in Little Rock, Arkansas, which there'd been a sort of back and forth about, and which Governor Orville Faubus, it's really a great name of history if he wasn't such a virulent racist, but Orville Faubus refuses to integrate schools and actually calls out the Arkansas National Guard to resist the integration of Central High and Little Rock. And the court hears this case, Cooper v. Aaron, in which Arkansas basically says, like, screw you, we're not doing this. And it's in that case that all 9 of them sign the opinion. Right? There's plenty of cases, there's cases every term that are unanimous, that all of them are on one side. Cooper is unique because they all put their names. It doesn't say Chief Justice Warren issued the opinion of the court. It says Chief Justice Warren, justices, and then it lists all their name, issues the opinion of the court. And it basically says, we told you to do this. You have to do what we say. Now go do it. And that was a really powerful statement from the court, including the new members. There's a line in it that says, a few of our members have departed, but the new members are in full agreement with us that this is the law of the land. It's a good question. There was an article. So the question is, if Hillary's elected, will the Republicans immediately move to confirm Merrick Garland on the thought that Merrick Garland is a more moderate justice than they're likely to get from Hillary, perhaps? And it's true. Garland is, if I had to place Garland ideologically on the court, he's probably right about where Stephen Breyer is, right? He might be slightly more conservative than Stephen Breyer, especially in criminal justice issues. Garland was a former prosecutor. He helped prosecute the Oklahoma City bombing and all of that. He's certainly not as liberal as Ginsburg and Sotomayor or even Kagan, but he's clearly on the left of the court. But he is not a far-left judge. He's a kind of center-left judge that Republicans used to talk about. In fact, as of last year, Orrin Hatch was saying, Merrick Garland, that'd be a good judge, or a good Supreme Court appointment. So will the Senate Republicans, if they lose the Senate or they lose the election, rather, the presidential election, immediately vote to confirm him? I don't know. I go back and forth about this with my colleagues. On the one hand, you've got a bunch of them, including Mitch McConnell, on record as saying the next president gets this appointment. So it would be blatantly disingenuous and craven to go back on that. On the other hand, Mitch McConnell, I'm sorry if anyone's a fan, has no problem being blatantly disingenuous and craven. So it's not clear to me that he doesn't do that. I think there's a number of members of his party who are resistant to doing that. But there are also a number of members who are pushing that. Jeff Flake from Arizona, who's the one in the very public tiff with Donald Trump right now, or has been in the public tiff with Trump. Flake says we should do this. We're not going to do better than Garland. And by everyone's account, Garland is eminently qualified. There's no one who disputes that except really the radical fringe wingnuts. But there are members of the party who don't want to do this for the following reasons. Not because they think they're going to get better under Hillary, but because they fear their own primary voters are going to punish them for capitulating to the Democrats. So if you followed Paul Ryan's primary battle in Wisconsin at all, right? Paul Ryan had a primary challenge. The Speaker of the House had a primary challenge. And Paul Ryan is a very conservative member of Congress, right? Let's make no bones about that. Paul Ryan was criticized by his primary challenger for being a lapdog of Barack Obama and Hillary Clinton, right? So now the challenger lost that election. Ryan wins, but there are senators, I think about Jeff Sessions, for example, or I think about Mitch McConnell, or I think about Ted Cruz and John Cornyn. There are senators for whom their constituents want them, more than winning on policy grounds, to stick it to the opponents.
But aren't senators a little less vulnerable to that sort of pressure in primary than a member of the House of Representatives?
I mean, it depends on, they're a little less vulnerable, but if they're up for re-election, they're still vulnerable, right? I mean, part of the reason John McCain has still not denounced Trump after Trump says, I don't like people who get captured. I prefer people who don't, right? Which was the first of 400 statements that people thought was going to sink Trump's chances at the presidency. McCain has not denounced him, right, for that. He didn't go to the convention, and he says, I have problems with it, but he hasn't denounced him. Why? Because he's got a primary challenger this fall, right, before he even gets to run in the general. And then he faces, now watch, as soon as McCain wins his primary, the next thing Trump says that offends McCain, McCain's going to denounce him, because then he's immediately going to pivot to the general. So yes, they're a little more inoculated. But what they're not inoculated against is fundraising issues, right? And ties into special interests and super PACs that want more than anything else blood. Sir. So the question is, how do you interpret the Bill of Rights, a document or a set of provisions from a different era and a different time, given contemporary contexts and changes in American politics? I mean, it's the $500,000 question to some degree, and it's been the root of the confirmation wars and the constitutional wars of the past 30 or 40 years, right? One whole approach to this, which was identified more with Antonin Scalia more than with anyone else, is what's known as originalism, right? You interpret the document and its provisions in light of how they were understood at the time. Okay, so Scalia says, look, we wrote these things down. They're fundamental. What speech meant in 1789, that's what we have to understand speech to mean. Now, Scalia will say that, and yet he doesn't even really do that, right? Or didn't even really do that. But for the most part wants to say, well, look, that what's written down needs to be taken as sacred, and it needs to be interpreted not according to changing values, but to fixed and fundamental ones. Otherwise, we're just changing what the Constitution means with every new era, right? And then why write things down if you're just going to change what they mean? The other approach, what has generally been referred to as a kind of living Constitution approach, though that terminology has kind of fallen out of fashion, and someone like Stephen Breyer talks about it as kind of pragmatism now, is to say, well, look, obviously, the purpose of the document is to bring about a certain form of government, right, of constitutional democracy. And at the heart of constitutional democracy is a tension between constitutionalism and democracy. We put those two words together as though like they're peanut butter and jelly and they automatically fit, but they don't, right? Constitutionalism is about limiting things that political majorities can do, and democracy is about empowering political majorities to do things. So Breyer says, look, you can't interpret it wholly as being in a fundamentalist way. That was the word you used. It's sort of rigid and strictly. You have to recognize that the document needs to be read in light of the function it performs in society, not just at this particular moment, but over our whole scope of history. And you have to balance, now, how you balance, he doesn't have particularly great advice for us, nor does Scalia, but you have to balance needs and consequences and pragmatic outlooks with what's written down. I mean, freedom of speech, to take the First Amendment, what does speech mean? Does it only mean the spoken word? Does it also mean the written word? Okay, the founders probably would have said it meant the written word in some capacity too, but the founders didn't know of the internet. Does it protect a blog post, right? I mean, or a term and a half ago, there was a case about a man threatening his ex-wife on Facebook, right? And claiming that they were rap lyrics, and it was protected by freedom of speech, right? So, clearly that wouldn't have been thought about to be speech by the founders, but today we would say, well, yeah, if you write something down on your personal, blog, or you send it in an email, that's a form of expression, right? We've broadened speech to include expression. Or, there's, I can pull out my pocket copy of the Constitution, right? I mean, the Seventh Amendment, right? So, the Seventh Amendment, in all in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. $20, right? That was the sort of standard. Well, $20 meant a lot different in 1789 than it means today. Right now, so, legislative districts, right? Vermont has one at-large district, right? But, legislative districts are approximately 700,000 citizens per district. That's how you try to apportion them. What most people don't know is the Bill of Rights was originally 12 amendments. There were 12 amendments originally submitted, right? And the first 2 amendments were not ratified. The original Second Amendment is then 200 years later ratified as the 27th Amendment, and it prohibits Congress from raising its own pay, basically. But the original First Amendment was supposed to limit the size of a congressional districts to 30,000 people. 30,000 people. I mean, someone with a calculator or a better math mind than I will need to figure out how many people, how many representatives we would need to have in the US Congress if we had a constitutional amendment saying 30,000 was the limit on what legislative districts could hold. So it's written for a different nation. It's written in a different time. And so, not Justice Scalia, but what a lot of legal theorists try to do is to say, well, let's take the concept that's embedded there, not the particular conception. Let's take the concept of what freedom of speech meant and apply it given the current times, given what speech, not totally disregard what it meant then, but view the concept as what we're paying fidelity to, even if our conceptions of what speech is or what the high enough dollar amount to guarantee a jury trial is. But this is something on which there is perpetual war over, and if you go to, I was going to say any law school class, any constitutional development class, any class of mine, you'll see that students are articulating these different things. Well, why do we bother writing it down if we're just going to disregard it when we don't like it? On the other side, but why should we be ruled by the dead hand of the past when we're growing and changing? So that's the sort of split on both sides. Thanks very much.